Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Afna binti Muslimin, and in this short video, I will explain the sources of international law as stated under Article 38 Clause 1 of the Statute of the International Court of Justice, which is ICJ, the hierarchy, and how they apply in real cases. In Article 38, Clause 1 lists 5 main sources that the ICJ uses when deciding case. First, we have treaties, also known as convention or agreements between states. Treaties are written agreement that creates binding legal obligation. For example, the United Nations Charter and the Vienna Convention on the Law of Treaties are the key example of treaty law. Second, there is customary international law. This refers to practices that states consistently follow out of sense of legal obligation, which we call opinion juris. For instance, the principle of non-use of force in international relations has become part of customary international law. And then thirdly, general principles of law are those principles common to major legal systems of the world, such as good faith, equity, and the rule of law. These help fill gaps when neither treaties nor custom provide clear answer. And then fourth, judicial decisions from the ICJ or other international tribunals serve as guidance. Although they are not binding beyond the specific case, they help maintain consistency and clarify legal rules. And lastly, writings of publicists refer to opinions of well-known scholars like Oppenheim or Brownlee, which are used as persuasive authority to interpret or explain the law. In international law, there is no strict hierarchy among the primary sources. Treaties, custom, and general principle are all considered primary sources, depending on which applies to a particular dispute. Meanwhile, judicial decisions and writings of publicists are subsidiary means. It means they help confirm or interpret what the primary sources mean, but do not create law on their own. A good example is the North Sea Continental Shelf case in 1969, where the ICJ explained how customary international law is formed through consistent state practice and legal belief, opinion juris. Another example is Nicaragua and United States in 1986. In this case, even though the United States was not bound by a specific treaty, the ICJ held that certain rules, such as the prohibition of force, existed under customary international law. These cases show how international courts apply different sources together to reach a fair and legally sound judgment. So, in conclusion, the sources of international law under Article 38, Clause 1 work together to create a complete legal framework governing relations between states, while treaties, custom, and general principle form the foundation judicial decision, and scholarly writing play a vital supporting role in interpreting and developing international law. Thank you for listening. Bye!